we'll start. So good morning, ladies and gentlemen, and Happy New Year. Thank you very much for joining us today for our roundup of some of 2020's key insurance cases. My name is Andrew Tobin, and I'm a partner in our London office, specialising in insurance and reinsurance. Our standard cover talk sessions are only 15 minutes long. This one-off cover talk plus session will be about 45 minutes, but in the spirit of our usual format, we will try to summarise each case in as short and snappy a way as we can. Today, we'll be looking at some cases on duty of disclosure, aggregation in a professional liability context, a D&O case, a case on double insurance, and 3 cases from the world of property insurance. We won't be discussing the COVID BI case today because we'll be having a specific session on that on the 4th of February, hosted by Ben Hardiman and Charlie Andrews, following the Supreme Court's judgment, which will be handed down tomorrow. This session is being recorded and will be posted on our website, and the slides will be emailed out to you following the session. You can see us, but we can't see you. If you have questions as we go along, please put them in the question and answer box, where my colleague Harriet Strevens will try and harvest them for us to address at the end. Your other speakers today are Stephen King, a partner in our Norwich office, who heads our insurance team nationally and who has a focus on healthcare liability. Claire Roake, a principal associate in our London office, specialising mainly in professional indemnity. And last but not least, Niall Innes, who leads our Manchester office and who also specialises in professional indemnity. So with the introductions over, I'd like to ask Stephen King to start us off.
Good morning. I have 2 cases I want to present. Both deal with issues around disclosure. The Acorn finance case was decided in April 2020 and involved non-disclosure, misrepresentation and breach of warranty. Although the case was decided under the law predating the Insurance Act 2015, the decision includes a discussion and ruling on the effect of an unintentional non-disclosure clause in a policy of insurance, which remains highly significant. The case involved negligent valuations of agricultural property undertaken by a surveying and valuation business, CLS, for the claimant, which was a bridging finance lender to mainly agricultural businesses. The claimant secured default judgments against CLS for a total of just over £13 million. In seeking to argue against the enforcement of those judgments under the Third Party Rights Against Insurers Act 1930, Markel relied on non-disclosures and misrepresentations amounting to breaches of warranty about the nature of valuation business carried on by its insured, specifically its involvement in valuations carried out for subprime lending. In concluding it was entitled to avoid cover, Markel wrote to its insured in February 2016, purporting to decline cover for what it said were deliberate and dishonest misrepresentations and non-disclosure. Responding to that, the insured argued that any breaches of duty had been waived by Markel's conduct and were to be disregarded in any event because of the existence of an unintentional non-disclosure clause in the policy. And it was this clause and its application which held the key to the outcome of the case. The clause was expressed in subjective terms, namely that Markel agreed to waive the breach of duty if the insured was able to establish to its satisfaction that the non-disclosure or misrepresentation was innocent and free from any fraudulent conduct or intention to deceive. Following the decision of the Supreme Court in Braganza and BP Shipping, it was necessary to imply a term into the policy to the effect that Markel wouldn't exercise its decision-making powers arbitrarily, capriciously, or irrationally. So the question was, had Markel acted contrary to that implied term? It might have done that by failing to take into account relevant matters, or by taking irrelevant matters into account, or by coming to a conclusion that no reasonable decision-maker could have reached. Ultimately, the issue was the quality of the decision that Markel made and whether it had approached the question of the nature of the non-disclosures and misrepresentations with an open mind. Specifically, had it taken full account of the knowledge of the insured that whilst it knew of Markel's reluctance to insure involved in subprime lending valuations, the insured had understood that reluctance related to residential property, not agricultural. Adopting the criteria from the Braganza case, the judge held that Markel had failed to approach the dishonesty issue with an open mind and hadn't taken into account the probability that the misrepresentations on non-disclosures were innocent or negligent rather than fraudulent. It had been wrong for Markel to assume that there had been dishonesty. Markel had allowed the subjective, albeit genuine, belief that there was dishonesty to prevail, and for that reason, it had misapplied the clause and had no right to avoid. The principle from the Braganza case, which is a Supreme Court case of general application, requires the decision maker, in this case Markel, to bear in mind that it is inherently more probable that a misrepresentation has been made innocently or negligently rather than dishonestly in arriving at their conclusions. Next slide, please. The second case is that of Young and Royal & Son Alliance. This was a Scottish case heard on appeal to the Inner House of the Court of Session in May 2020 and concerns the meaning of the duty of fair presentation of risk in the Insurance Act 2015 and whether insurers had waived disclosure of facts that would have been material to the scope of questions they posed. The facts were that a fire sufficiently destroyed a commercial property in Glasgow in 2018 that it had to be demolished. The loss was a little over £7 million. The insurance cover for Mr. Young, who was the insured, had been obtained following a market presentation prepared using software of the broker, which referred to Mr. Young as the controller of a company called Kame Park Investments Limited, whose business was property development and ownership. The software exercise required answers to a moral hazard declaration in the form of a drop-down menu, which referred to a number of propositions, one of which asked whether a proposer, director, or partner of the insured had ever been bankrupt, insolvent, or subject to those types of proceedings. That box was left unticked, so what RSA saw was the word none, which was inserted in response to the moral hazard declaration. RSA didn't know which of the propositions the word non referred to. The presentation was followed by an email from RSA attaching its terms and stating that the insured had never been declared bankrupt, insolvent, or had a liquidator appointed. The broker responded to confirm the accuracy of the information in the email. Although the statement in the market presentation was accurate in that the claimant, Mr. Young, had never been insolvent, he had been a director of 4 companies that had become insolvent and placed into insolvent liquidations. RSA avoided the policy on the basis of Mr. Young's failure to disclose that information, and the question was whether RSA had waived disclosure. It was agreed that Section 3 of the Insurance Act requires an insured must make a fair presentation of risk before an insurance contract is entered into, which means disclosure of every material circumstance the insured knows about. Section 7 of the Act says that material information is that which would influence an insurer in deciding to take on the risk and on what terms. The claimant argued it was settled law the duty of disclosure could be restricted by the actual questions posed by the insurer, as decided in Doney and New India Assurance and R&R Developments and AXA. Further, the claimant argued there was an express saving for waiver in Section 3, subsection 5 of the Insurance Act, stating that there was no obligation to disclose a fact if it was something as to which the insurer waives information. Here, the claimant argued the moral hazard stipulation was deliberately restricted to insolvency events affecting the personal position of Mr. Young, not the companies he was involved with. But RSA, they said Young's links to insolvent companies potentially indicated a wide range of failings by Mr. Young, and so was material information. RSA's case was that the breach of duty here was the omission in not providing the information with the market presentation. How could RSA have waived disclosure of information they didn't know hadn't been disclosed? The facts were very similar to the R&R case, where questions about the personal insolvency of the assured didn't extend to the insolvency of other companies the individual might have been associated with. The ruling of the outer house was around the following question: would a reasonable person reading the proposal form be justified in thinking that the insurer had restricted its right to receive all material information and consented to omission of the particular information not disclosed? Clearly, on the facts, this was not the case. RSA was unaware of the options in the drop-down menu the brokers were using to complete the market presentation. Accordingly, the market presentation couldn't be intended to be the entirety of the information to be presented to RSA, so couldn't give rise to a waiver. RSA's subsequent email was an attempt to elicit the content of the declaration and wasn't designed to waive information. On appeal, the inner house agreed with the outer house. Where there was reliance of this type, the expectation is that there would be a form of inquiry by the insurer asking for specific information. The words in the RSA email, "Insured has never been declared bankrupt or insolvent," were not inquiries by RSA of a type that would waive disclosure, but simply the terms that RSA was offering. To conclude, the principles relating to waiver haven't changed from those applicable under the old Marine Insurance Act 1906. They are that the Act requires an insured to make disclosure of every material circumstance which the insured knows or ought to know. That to make disclosure of sufficient information to put a prudent insurer on notice that it needs to make further inquiries. To make such disclosure in a reasonably clear and accessible manner, and to ensure that every material representation of fact is substantially correct, and every material representation of expectation or belief is made in good faith. The practical consequence is that insurers should ensure their communications to brokers and insureds are not inadvertently construed as inquiries that might limit the duty of fair presentation. Thank you. Claire Roake will now speak on the subject of aggregation.
Thank you. So I'm going to consider two cases from towards the end of last year on aggregation. The first of all is Lord Bishop of Leeds and Dixon, Coles and Gill, which concerns the aggregation of claims under the solicitor's minimum terms, and more specifically, what constitutes one act or omission or a series of related acts and omissions. The second case is Spire Healthcare and Royal Sun Alliance, in which the focus was on the meaning of original cause. So next slide, please. Turning to the first case of Lord Bishop of Leeds and Dixon, Coles and Gill. Dixon, Coles and Gill was a long-established three-partner firm of solicitors, and its senior partner was Mrs. Box. On Christmas Eve 2015, to their horror, the firm's two other partners discovered that Mrs. Box had been stealing from client account. Mrs. Box was promptly expelled from the firm. Investigations followed in which it was discovered that Mrs. Box had been stolen over £4 million from various clients over a number of years. Mrs. Box was later jailed for 7 years. Now, as you would expect, Dixon Coles was faced with a number of claims from a number of clients, and proceedings were brought by two different sets of clients. Dixon Coles' professional indemnity insurer was HDI Global, and its policy had an indemnity limit of £2 million, any one claim. Now, in accordance with the Solicitor's Regulatory Authority's minimum terms and conditions, HDI was obliged to indemnify Dixon Coles' two innocent partners. Now, HDI argued that all of the misappropriations from client account should be classed as a single claim with one limit of £2 million applying. And if that was right, there would be a further £2 million uninsured exposure. Dixon Coles challenged HDI's position. It made a claim under the Third Party Rights Against Insurers Act 1930 for a declaration that each of the two claims against Dixon Coles should be treated as a separate claim with a separate £2 million limit of indemnity. Now, the aggregating provision in the solicitor's minimum terms is set out on the slide, and it's the first two parts that were relevant in this case. So were all the thefts one act or a series of related acts? So looking at first at whether they were one act, the minimum terms defines a claim to include any obligation on the part of the insured firm to remedy a breach of the SRA account rules. And in this case, the obligation was to replace the client funds that Mrs. Box had stolen. HDI argued that Dixon Coles' obligation to remedy the breach of the solicitor's accounts rules was one indivisible obligation, and therefore there's one claim. It was also argued that Mrs. Box's dishonest conduct constituted a single act. HDI used the analogy of building a house. So quoting from the judgment, an individual engages in a single act when he builds a house. That may involve a number of individual steps, but at the end of the day, there is one act intended. Now, the court rejected that analysis. It instead accepted Dixon Coles' case that each theft was a separate dishonest act. Using HDI's own analogy of house building, the court stated that the situation of multiple thefts was more akin to a whole housing estate. Quoting again, there may be a single intention to build a housing estate in the same way that Mrs. Box may have had the single intention of stealing as much money as possible, but each house and each theft must be a different act, although they may be taken with a view to accomplishing one ultimate objective. HDI's alternative argument was that the thefts were sufficiently related so as to constitute a series of related acts. HDI argued that Mrs. Box's practice of teaming and lading, by which HDI was referring to the use of monies from one client to cover up the theft committed in relation to another client, was a unifying factor. And in considering this argument, the court referred to the earlier House of Lords and Supreme Court decisions in Lloyd's TSB and General Insurance and Lloyd's Bank Group and AIG and Woodman. And based on those authorities, the argument that the thefts were a series of related acts was also rejected. The court found that in order for the thefts to be related, there must be a sufficient interconnection or unifying factor between them. The fact that the thefts were all committed by the same person and concealed by the same process was not enough, nor was Mrs. Box's dishonesty the proximate cause of the claimant's losses. What caused the loss were separate thefts from each claimant. In the judge's view, a broader meaning, allowing thefts from different clients over a period of many years, would result in aggregation being almost limitless. So HDI could not aggregate the claimant's claims and faced liability of £4 million rather than £2 million. So moving on now to the second case of Spire Healthcare and RSA. Now this case concerned the meaning of original cause as an aggregating factor. And again, the relevant words are on the slide. Now, this dispute arose out of the actions of a rogue surgeon, Ian Patterson, who was ultimately jailed for 20 years for carrying out unnecessary mastectomies. Now, Mr. Patterson worked on the NHS, and he also had a lucrative private practice working at 2 Spire hospitals. Now, there were 2 aspects to Mr. Patterson's wrongdoing. First, he carried out unnecessary surgery on healthy patients. And in virtually all these cases, the patients were treated privately. So it seems clear that Mr. Patterson's motivation was financial gain. And second, in both Mr. Patterson's NHS practice and his private work, he performed partial rather than full mastectomies on patients who had breast cancer. And this exposed those patients to the risk of the cancer returning. And it seems that Mr. Patterson adopted this negligent practice either to save time or for aesthetical reasons. The Spire faced claims from about 750 of Mr. Patterson's patients. It was insured under a policy written by RSA, and the limit was £10 million for all claims consequent on or attributable to one source or original cause. Now, RSA argued that all the claims were caused by the same person, Mr. Patterson, and or Mr. Patterson's negligence or dishonesty. And if that was right, RSA's exposure under the policy would be limited to £10 million. Spire, on the other hand, argued that there were 2 causes arising from the 2 different types of case. So first, those patients who'd had unnecessary surgery, and second, those patients who'd been the victim of negligent partial surgery. And if Spire was right, RSA's exposure would be £20 million. Now, as you'd expect, in reaching its decision, the court considered the existing case law on the meaning of original cause. So in summary, original cause involves the widest possible search for a unifying factor. This is in contrast to where aggregation is by reference to an event or occurrence, which is a much narrower aggregating factor. In looking for the original cause, the losses should be traced back to wherever a common origin can reasonably be found. And there must be a causative link between what is contended to be the original cause and the loss. And cause is the description of why something has happened, which could be the reason why an individual has acted in a particular way. Now, having considered those legal principles, the judge determined that to aggregate the claims, RSA must establish that all the claims arising from Mr. Patterson's actions were attributable to a common origin with an effective causal link to the losses that it was seeking to aggregate. And applying that to the facts of the case, the court concluded that the causal differences between the two groups of patients were too great. In the instance of the cases where surgery was unnecessary, the cause of the loss was Mr. Patterson's greed. Whereas in those cases where partial mastectomies were carried out, the cause was Mr. Patterson's incompetence. So in financial terms, that meant that Spire was entitled to £20 million and not just 10 million from RSA. So in conclusion, generally, I don't think that either of those cases change the law. They are, however, a useful reminder that first, ultimately, any case is going to turn on its own specific facts and the wording of the aggregating clause to which those facts are applied. Second, it will generally be difficult to demonstrate that discrete acts are sufficiently connected to allow the aggregation of multiple claims. And third, even where wide aggregating wording is used, there can be significant challenges when seeking to aggregate claims. So thank you, and I'll now hand over to Niall, who's looking at D&O and other insurance.
Thank you very much, Claire. I'm going to talk about two cases. One relates to an exclusion in a D&O policy, and the second addresses issues of double insurance. They're both Australian decisions, so neither are directly binding in English law, but they will be useful when the issue crops up on your cases. So the first case is AIG Australia and Koboco Mining. It was a case which was heard in the Federal Court of Appeal, and it addressed an exclusion within a D&O policy for insurance, for insolvency. Koboco was selling a substantial volume of manganese ore, and in doing so, the purchaser advanced to them substantial funds. The advance involved specific warranties, that Koboco had all the necessary permissions to mine and sell the ore, and that they would not sell it to anybody else without first seeking permission from the purchaser. Koboco were in breach of both of those warranties, which led as a breach to allow the purchaser to demand repayment. Koboco defaulted because they weren't able to repay the advance, about $5 million. And so as they weren't able to pay their debts, administrators were appointed. When the administrators investigated the matter, they issued proceedings eventually against 3 of the company's directors. AIG had provided D&O cover for the company, both for liability and defence costs. And the question was whether the claim, the insolvency exclusion applied. Now, the terms of the exclusion were that any loss in connection with any claim arising out of, based upon, or attributable to the actual or alleged insolvency of the company, or any actual or alleged inability of the company to pay any of its debts as and when they felt full due. So AIG argued, as you might expect, that there was a sufficient causal connection between the claim and the insolvency, and that arising from should be given a wider test than something just being approximate cause. I'm afraid that at both first instance and on appeal, the claim failed and the exclusion was found not to apply. Because effectively, although the breaches led to the insolvency, the claim itself did not arise out of it. The claim was the failure to make a profit on a commercial opportunity as a result of the defaults by the directors. And the important point was that the exclusion applied where any claim arose out of insolvency. If it had applied to any loss arising out of insolvency, then the position may well have been different. The decision is useful to bear in mind when you're looking at similar exclusion clauses, whether in a D&O or any other policy, frankly. And it really reinforces the need to very carefully analyse the exact scope of what's being excluded against the underlying factual matrix. And you can see more about D&O policies generally and how they work if you go back to the webinar that Neil Howes did on this series on the 17th of December, which you'll find on our website. The second case I'm going to take you to, when it moves forward, is a double insurance case. It's the case of Allianz and Lloyd's. This is a case which arose out of a substantial employer's liability claim. An employee had been hit by a car whilst he was working during the construction of a road, and he was seriously injured. There were 2 policies. Allianz provided a contractors all risk policy. Lloyd's provided a public liability policy. Both included other insurance clauses by which they sought to avoid their own liability as a result solely of the existence of the other policy. Now, in Australia, such clauses are ordinarily rendered void by statute, but that provision didn't apply in this case, since although the employer was an insured under each policy, the employer had not been the contracting party, which is what the statute required. Therefore, the court had to look at and construe both clauses. Now, the Lloyd's policy excluded liability. It was an escape clause. And the exclusion bit where the liability forms the subject of insurance by any other policy. So they said, because of the existence of the Allianz policy, theirs did not respond. The Allianz policy contained two relevant clauses. The first was an excess cover clause. The effect of that was that where there was other valid and collectible insurance, Allianz would sit above that other policy, and theirs, the Allianz policy, would not respond until the limit under the other policy had been totally exhausted. There was a second relevant clause in the Allianz policy, which was an underlying insurance clause, which required Allianz to meet a claim if an underlying insurance policy insured the risk but didn't respond to it. Now, these proceedings were by way of contribution, since Allianz had paid out the claim in the first instance, so the injured employee at least got his money, and they were seeking a claim for contribution from Lloyd's for the outlay. Now, first instance, the court accepted that in the ordinary way, two competing exclusion clauses would, by common law, cancel each other out. However, the judge accepted that the underlying insurance clause left Allianz in the position that they were liable because Lloyd's policy did not respond, and therefore the judge at first instance concluded that this shouldn't be approached as a classic double insurance case. As such, the judge said that the Allianz policy did still respond because of the underlying insurance clause. The Lloyd's policy did not, and there should be no claim for contribution. So Allianz took the matter to appeal, and by a majority, the appeal was allowed. And the Court of Appeal in Australia gave what we would probably have expected to be the outcome. They concluded that the Lloyd's policy was an exclusion solely because of the existence of the Allianz policy. And the effect of an excess cover clause is the same as an exclusion because it rendered the Allianz policy such that it sits in excess over the Lloyd's policy. Therefore, in the ordinary way, those two clauses cancelled each other out. Now, the difference between the Court of Appeal and first instance is that because the Lloyd's escape clause was cancelled out and therefore did not apply at all, the Court of Appeal concluded that the underlying insurance clause had no application. Therefore, they approached it as a classic double insurance claim. Both clauses cancelled each other out, both policies responded, and no doubt Allianz and Lloyd's had to resolve the contribution claim as between them. I should say also that if you want to know more about how double insurance works more generally, I suggest you also have a look at the Cover Talk webinar from the 19th of November, which is also on the website, which Liam Burnett and Adrian Quintner did. I'm now going to hand over to Andrew to discuss property insurance. You may need to unmute, Andrew.
Unmute, thank you, Neil. I'm going to discuss the three cases on the slide. The first two both concern the proper basis of indemnity for rectifying damaged property. Both of those cases ended badly for insurers. The third case also concerned rectifying defective property, but ended well for insurers who succeeded in showing that the claimant's claims were out of time. Next slide, please. Manchicalapati and Zurich was a case that came before the Court of Appeal just before Christmas in 2019, and so I think it just makes the cut for our 2020 review. And the main question in the case was, were insurers liable to indemnify an insured before any defect to the property had been rectified? The background here concerned two new blocks of flats in Manchester in which at least 100 individuals had purchased long leases and to whom Zurich had issued policies that covered the, quote, reasonable costs of rectifying defects, end quote. Unfortunately for the leaseholders, there were multiple defects with the property. The developer was insolvent, and so the leaseholders sued Zurich under the policies for the costs of repairing those defects. Zurich resisted liability. It said that because no defects had in fact been rectified, then its liability under the policy simply had not been triggered at all. In Zurich's view, quote, reasonable cost, end quote, meant actual or incurred cost, and that, in other words, they could only be liable after the insureds had spent their own money on repairs, which they had not in fact done. Both the High Court and Court of Appeal comprehensively rejected Zurich's arguments on this point for several reasons, including that the policy language worked perfectly well as it was. There was simply no good reason for reading in any extra words, and that if insurers intended only to be liable for incurred costs, which is sometimes the case under professional indemnity policies, for example, then they should have spelled that out clearly in the policy. Next, in the court's view, the reference to reasonable cost was only relevant to the amount that insurers were to pay, rather than to the question of liability itself. And the court also found that Zurich's interpretation was contrary to the overall purpose of the policy, because if the policy had worked as Zurich said it did, then, for example, even if the building was at imminent risk of collapse, insurers would have no liability until the leaseholders had spent their own monies to try and save it first. And that couldn't have been the intention of the parties. Or putting it another way, if the tenants did not all have the funds to pay for any repairs, which by the way seems to have been the case here, then if Zurich's interpretation was right, then insurers could never be liable. And that cannot have been the intention of the parties when the policies were issued. And so, in a nutshell, Zurich's argument that it had no liability because the tenants had not in fact incurred any costs in remedying defects failed. But Zurich had another argument to make. Zurich had discovered that the tenants had obtained litigation funding to pay for their legal fees. Under litigation funding arrangements, the funder pays the legal costs in return for a percentage of any recovery made. Now, Zurich argued that because the first slice of the insurance monies would go to the litigation funders, it wouldn't be going wasn't going to be spent on the remedial works, and that there was 2016 authority mentioned on the slide, the Great Lakes and Western Trading case, to the effect that an insured was only entitled to the cost of repair if in fact it intended to use the money for that repair. And so Zurich said it followed that because some insurance monies would go to the litigation funders and to their solicitors, the insureds cannot have intended to use all that money for the repair. And it followed, in Zurich's view, that the insured was not entitled to be paid on a reinstatement basis. The Court of Appeal rejected Zurich's argument on that point also, saying that the Great Lakes case concerned a very specific situation and did not lay down any general rule. The court said that the general rule remained, as set out on the slide, that on receiving insurance money, the insured may do what he likes with it, and he cannot be required to spend it on reinstatement. Therefore, the fact that the insured might share some of its recovery with litigation funders was irrelevant to the amount of Zurich's liability. Next slide, please. Related arguments were made before the Court of Appeal just a few weeks later in Endurance Capital and Sartex. This case is worth reading because it contains some very useful restatements of the law relating to the general approach to indemnity, mitigation, and betterment. But today I can touch on just a couple of aspects. The case concerned a factory fire in which property and machinery was damaged. The policy provided that insurers should quote, indemnify the insured against loss or destruction or damage to property. But the relevant part of the policy did not provide any further details about the basis of indemnity. For example, whether it was to be on a reinstatement or some other basis. And so the court had to approach the question from general common law principles. Now, Sartex, the insured, claimed that it was entitled to the cost of reinstating the property, not least because it was obliged to do so under the terms of its lease, and that before the fire, it had intended to continue to use the factory for manufacturing. The Court of Appeal looked at all of the case law and reaffirmed the general rule, which is quoted on the slide, that essentially where the evidence is that an insured intended to carry on trading from a damaged site, it's usually entitled to the cost of repair. But if the evidence is that the insured intended to sell the property, then the correct measure would usually be the reduction in market value caused by the damage. Now, there was evidence that before the fire, Sartex intended to continue using the premises to manufacture goods. So, on the face of things, Sartex would have been entitled to the cost of repair. However, insurers argued that what mattered here was not the insured's intentions at or before the time of loss, but what its intentions were at the time of trial, at the date of trial. They said that because no reinstatement had in fact been carried out, nor was there any evidence of any actual intention to do so at the time of trial, it would be wrong to allow indemnity on the reinstatement basis. And in support of that argument, they relied on the same passage in the Great Lakes case that Zurich had in the Manchika-Lapati case, in which the court had seemed to say, according to insurers, that insureds are not entitled to be paid to reinstate property unless they can prove an actual intention to do so. Anyway, the court disagreed with insurers and again distinguished the Great Lakes case, which it said was obiter and had been taken out of context. Rather, the correct approach here was to assess the insured's intentions at the date of loss, not at the date of trial. And in fact, it was none of insurers' business what the insureds might subsequently decide to do with any insurance monies. So the evidence in that case was that by the time of the fire, the insured was intending to continue to manufacture at the site. And so the result was that Sartex was indeed entitled to be paid for the costs of repair. Next slide, please. But insurers had a subsidiary argument about how much deduction for betterment could be applied to any claims payment. Insurers said that a reduction should be made for betterment because by repairing the property, the insured would benefit from reduced maintenance costs in light of using modern equipment and materials, and so on. Now, the judgment gives a very helpful summary of the general rules relating to betterment, which I don't have time to repeat just now, but I can happily send you the relevant passages if you drop me a line. However, the practical point here for all loss adjusters and insurers to note is that the court refused to allow any deductions for betterment because there was no proper evidence before the court to justify them. The Court of Appeal emphasised that the burden of proving deductions for betterment lay with insurers who must provide some evidence. And what they specifically said was on the slide, a broad approach to quantification for betterment is often appropriate, but some figure or method of estimating a figure needs to be proposed for which there is some rational or evidential basis, even if it is only rough and ready. The court cannot simply make a number up. In this case, the loss adjusters appear to have made some ad hoc betterment deductions of 10% here and 20% there, but without evidencing their rationale and reasoning. And for that reason, the court rejected the deduction. So I think in light of this case is a reminder that in cases of betterment, insurers and their loss adjusters need to be prepared perhaps a little bit more prepared than they would have been to justify any betterment deductions with evidence and reason. Next slide, please. The third and final case today concerns Griffis and Liberty Syndicate. It's a High Court case which concerns the running of time for the purposes of limitation periods. Now, in English law, claims in contract, including claims by insureds against insurers, must be brought within 6 years of when the cause of action accrued. And what we mean by that is that a cause of action accrues when a claimant has all of the legal ingredients necessary to be able to claim against a defendant. And the general rule for property insurance is very well established, namely that time starts running immediately upon the date of damage to the property. In other words, the insured has 6 years from the date of damage to sue its insurers. Now, the background here is that there was a leaky roof in a new build block of flats. Liberty had issued consecutive policies in 2008 and 2010, which were similar to each other in that they both covered the costs of repairing and rectifying defects, echoing some of the language we've mentioned in the other cases today. The tenants noticed defects around 2009 and wrote a letter of claim to Liberty on the 29th of March 2010, as you can see on the slide. That claim was then rejected on the 7th of June 2011, also on the slide. But for some reason, the tenants did not sue insurers until the 4th of January 2019, which was 10 years after the defects had been discovered. Now, because of our 6-year limitation period, that meant that Liberty would only be liable if the insured's cause of action arose less than 6 years before the 4th of January 2019. In other words, if the cause of action arose after the 5th of January 2013. But of course, in this case, the defects had come to light years before. So to try to get around this fatal problem to their case, the insured tried to adopt Zurich's argument in Manchikela Patti by arguing that because the policy covered the costs of repairing or rectifying defects or damage, and because no repairs had been carried out, then insurer's liability was never triggered and that the limitation period had never started to run at all. Next slide, please. It was a bold argument to make, but it was rejected by the court for 2 main reasons. Firstly, the usual rule in property insurance is that time starts to run from the date of damage, and very clear words would be needed to change that. That's the rule in Callahan and Dominion mentioned on the slide. Secondly, if the insureds were right, then the limitation period would never start to run if they decided not to or could not afford to repair the property. And that cannot have been the intention of the policy. And so, unsurprisingly, in my view, the insured's claims were found to be time barred. Now, those 3 cases I mentioned form can be seen as some kind of mini-series in that they address a number of related points. But standing back, what do they show? I think the main point is probably that there are long-established rules under English law, for example, relating to the basis of indemnity, betterment and limitation, and that the courts are very reluctant to depart from them unless the policy wording very clearly very clearly expresses that the normal rule should be departed from. And ladies and gentlemen, that concludes my presentation for today. I think we do have some time for some questions, if there are any. Harriet.
We have a very small amount of time, but just quickly, if I may, now you're all on screen together. Niall, if I might ask you please in relation to Allianz and Lloyd's, are you aware of any instances where the principle where you have competing clauses, the escape clause and the excess clause, have been applied in the UK? Presumably, if not, then this case is more likely to be persuasive.
Yeah, I think it's persuasive, Harriet. So no, I mean, there's various cases where you've got competing excess clauses or exclusion ones, but I'm not actually aware of an English one where you have an excess against an exclusion one. So I think it will be pretty persuasive. And let's face it, I think the court will want to find cover in these sort of circumstances. Effectively, if an insured has been prudent enough to take out 2 policies, it seems only right that he shouldn't be left in the position that he's effectively uninsured. Which is the contention otherwise. So I suspect it would be followed.
Thank you very much. Just 2 more quickly. Stephen, on the Acorn finance case, will an implied term about how a decision maker exercises its decision-making power always be implied into a policy where an unintentional non-disclosure clause exists?
Very simply, yes. And it's worth bearing in mind that the guidance in the Braganza case, that's a Supreme Court case, so of general application as well. And what they said very clearly is that it's inherently likely that any misrepresentation or non-disclosure is going to be innocent or negligent rather than fraudulent. So the onus of proof will be quite high.
Thank you very much. I'm going to pass back to you now, Andrew, because in keeping with our usual exercise of trying to finish on time, it's 11:47. So over to you. Thank you.
Okay, well, thank you very much for your time, ladies and gentlemen. Please do contact us directly if you have any questions. We will be really grateful for any feedback you have, and a questionnaire will follow. Our next 15-minute Cover Talk webinar will be on the 28th of January, when our Chris Goff from our Birmingham office will discuss handling personal injury claims, avoiding the pitfalls. And the Supreme Court judgment on the COVID business interruption case comes out tomorrow. Ben Hardiman and Charlie Andrews will discuss that on the 4th of February, and details will be circulated. But that concludes our session today. Thank you very much for joining us, and goodbye.